of the 2 weeks.
Excuse me. On premier by petitioner, this is matter of the 2 weeks.
That's it.
May it please your lordship, I beg to mention item number 2. On behalf of respondent 1 and 2. Respondent number 1 and 2, your lordship.
You have not been able to file your written argument. Have you filed?
Your lordship, I can refer for 2 weeks' time. Lordship, we were supposed to file our written synopsis, your lordship.
Have you done?
Yes, your lordship.
Have you done it or you will do it now?
We already done, sir, your lordship.
On premier by the respondent number 1 and 2 seeking accommodation. Matters adjourned in the system of the 2 weeks.
Deeply obliged, lordship. Obliged, your lordship.
Please, your lordship. Lordship, I beg to mention item number 7, 8 and 9. 7, 8 and 9.
You are for?
And for the respondent, your lordship.
Who's for the petitioner?
So item number 6, similar matter again, pertains to the same case, cancellation. Yes. Mention.
No objection, your lordship.
What is the stage of the case? The trial is going on.
Yes, Lordship.
Trial is going on.
One witness
It's on
has been
evidence
examined.
stage.
One witness.
How many witnesses are there?
I think a total of 10, Your Lordship.
Total of 10.
Total of 10, I believe. One is...
Are these accused person appearing?
Yes, your
they're
lordship.
regular. All of them. Although I'm not for them, but even they're regular.
Then what's the point? If they are appearing regularly,
Absolutely. There's no case made out actually, so seeking for cancellation of bail. But again,
on premier by the respondent, not objected to by petitioner. This is matter of the 3 weeks.
highly obliged.
Obliged, your lordship.
Good day, Your Lordship.
May I please, lordship? Lordship, I beg to mention item number 10.
Then
The conducting counsel is on sanctioned leave, lordship.
this is the same case. Or
Yes, lordship.
10 right.
On supplementary list, item number 1.
Please, Your Lordship. Your Lordship, on the last date, Your Lordship, when I have moved this application, the deposition of the last witness was not there. So the deposition now is available. I can. This was recorded on 12th September, sir. I'll give you a copy, sir. A copy. In fact, you know, the deposition of this particular witness, Your Lordship, there's nothing against me. In fact, he's going contradicting what the gazetted officer have stated. But that, you know, all those contradiction and all, I'll place before the trial court. But
Is he a seizure witness?
He is an independent witness, you know, and he have signed some documents as a Caesar witness as well. Independent witness.
How many witnesses are there?
There are eight witnesses, and 4 have been examined so far.
Oh,
4, Your Lordship. If I may be corrected, Your Lordship, along with the IO, it's 9 witnesses along with IO. So the independent witnesses and all other important witnesses have been examined. What is left now, Your Lordship, are only the official witnesses who have observed the Caesar and the IO.
see, Mr. Jarwa, you have to understand this is, you know, a case under Section 20.
Understood, Your Lordship.
C.
Yes.
So the rigors of Section 37 will apply.
If Your Lordship,
Under such circumstances, the court has to be convinced that the accused is innocent.
yes,
That is one thing which you have to prove,
yes, Your Lordship.
and that can only be, you know, ascertained by way of
Evidence.
evidence. Now, so far, about how many witnesses have been examined?
4, Your Lordship.
4. We are left with 5.
We are left with 5.
You might as well wait for the outcome.
Your
Sooner
Lordship,
or later, it will come.
I'll again reiterate, Your Lordship, since on the last occasion I've taken Your Lordship to the deposition of a very important witness in this case, Your Lordship, which is at 184. This particular witness, Your Lordship, he is an officer who have received the information with regard to the this vehicle carrying contraband. So it is because based on his information which have given to the complainant that the FIR was launched. So, Your Lordship, as per his testimony, Your Lordship, because my case is, Your Lordship, I am not involved directly or indirectly in this matter. I am just a co-passenger traveling in the tourist vehicle for my personal purpose to meet my children who are in Guwahati. And the arrest, Your Lordship, was only based on the CDR record, which as per the charge sheet, Your Lordship, they have clearly reflected that since 1st of June, they have seen that I have been in contact with the co-accused. And the contraband, Your Lordship, which is very important because that will show whether I have in conscious possession or not, Your Lordship, of the contraband. From the entire record, Your Lordship, there is no evidence whatsoever to show that I have knowledge so as to implicate me under Section 29 of the NDPS, Your Lordship. And from the statement which is at 184, Your Lordship, the witness deposed this in court, that it is a fact that I was a part of search and seizure team. It took about 1.5 to 2 hours to complete search of the vehicle as the contraband were hidden in various compartments of the vehicle. Your Lordship, so Section 35 will also come into play, Your Lordship, of the NDPS Act. Section 35 talks about the culpable mind, state of mind of the accused. Your Lordship, 35. Presumption of culpable mental state, Your Lordship. Your Lordship, allow me, I'll read.
Yes.
It reads, Your Lordship, in any prosecution for an offence under this act which requires a culpable mental state of the accused, the court shall presume the existence of such mental state, but it shall be a defence for the accused to prove the fact that he had no mental state with respect to the act charged as an offence in that prosecution. The explanation, Your Lordship. What does the culpable mental state means? It includes intention, motive, knowledge of a fact, and belief in or reason to believe a fact. And clause 2, Your Lordship, is where my case is. For the purpose of this section, a fact is said to be proved only when the court believes it to exist beyond reasonable doubt. So I mean the fact that I know that the contraband is there, it has to be shown that it exists beyond reasonable doubt. And not merely when its existence is established by a preponderance of probability. So there has to be a material, Your Lordship, so as to implicate me under section 29. Since the vehicle is not mine, the contraband is in a hidden compartment, where is the evidence that I'm also involved, directly or indirectly, in this matter? And from the material available on record, from the charge sheet, and also the deposition of the witness, Your Lordship, nowhere has there been a material evidence against me to say that I am aware, I have led to the discovery. In fact, Your Lordship, under section 27, procedure have also been complied, 27 of the Evidence Act. The contraband was not led by me. It is on record. Your Lordship, I'd like to take Your Lordship.
Was the driver also an accused?
Yes, Your Lordship. The vehicle, Your Lordship, it's very important.
What is the evidence against him?
The evidence is that, Your Lordship, he is the driver of the vehicle, and the contraband was seized from the hidden compartment. So I'll not pin anything on him also, Your Lordship. I'm simply minding my own case, Your Lordship, and that is that, Your Lordship.
If you say that the contraband were hidden in certain compartments,
yes,
within the vehicle,
yes,
the vehicle does not belong to the petitioner here.
Yes, yes.
It belongs to somebody else.
Yes.
Driven by somebody else.
Yes, Your Lordship.
So either the owner of the vehicle or the driver of the vehicle,
yes, Your Lordship,
should be, should be in the know as to how the whole operation had occurred.
Yes, Your Lordship.
So now let's see your connection with those two accused, co-accused.
Your Lordship,
was the owner also arrested? Owner of the vehicle?
The owner is not there, Your Lordship. It is only the co-accused who is the driver, and with another person. There are 3 accused persons in this case, including myself. One is the driver, and one is the person who, as per the investigation, he is supposed to be the person to whom the contraband is to be delivered. So he's there.
He was not in the vehicle.
He was not there at the time of
So you are the only passenger there in the vehicle.
I'm the only passenger, Your Lordship, because I was travelling. Your Lordship, I'll just come to as per section 35, Your Lordship, to say that whether just my mere presence there, Your Lordship, whether saying that because I was there, whether it'll be justified to also implicate me under section 29, whether indirectly or directly, Your Lordship, with regard to the... I'll just like to take Your Lordship to one judgment, Your Lordship. This is passed by the Orissa High Court, Your Lordship, while relying on the Supreme Court judgment, Your Lordship. This is on conscious possession, Your Lordship. The relevant paragraph for me, Your Lordship, is at para 10, which is page 5 of that judgment, Your Lordship. Para 10.
Yes.
I'll read, Your Lordship. Another decision on which reliance is placed is the decision of Honorable Supreme Court in the case of so-and-so, wherein it has been held as follows. However, we notice that as far as accused 1, appellant 1, herein is concerned, the contraband in question has been seized from his possession, and in our opinion, the prosecution has established the case against the said accused, and the court below has rightly convicted the said appellant. Whereas, in regard to appellant number 2, it is a prosecution case itself that he was travelling in the auto rickshaw along with 3 other persons. The prosecution has not produced any material whatsoever to establish that either this appellant had the knowledge that the appellant number 1 was carrying the contraband or was in any manner conniving with the said accused in carrying the contraband. In the absence of any such material, to convict the second appellant only on the ground that he was found in the auto rickshaw, in our opinion, is not justified. So, Your Lordship, this is also my case, that simply my presence there does not make me also part of the commission of any offence under this act. And the only material available, Your Lordship, as per the confidence which we have seen from the charge sheet, that they have a CDR against me, and that too from that since 1st of June, I was in touch. 1st of June, the arrest was on 19th June, so not even a month, Your Lordship, to show that I'm a habitual offender, or maybe that I'm also involved in these type of activities, so as to create that perception, Your Lordship, that if I be released on bail, I'll again go into committing further offence under this act. Your Lordship, there is no material whatsoever against me, and even from the testimony of the witnesses so far, Your Lordship, it says so, that with regard to the knowledge of the with regard to the vehicle also, Your Lordship, I was just an occupant in the vehicle. It is a tourist vehicle. Had it been a private vehicle, again, maybe, Your Lordship, that'll be a different story altogether, but it's a tourist vehicle. My children, I've annexed the documents to show that my children are there in Guwahati, Your Lordship, during the schooling. Because of the conflict in my district in Chorochandpur, I was simply a traveler, traveling through a tourist cab, Your Lordship. And it was at that point of time that when the vehicle was intercepted, I was also involved. There are no material whatsoever up except the FIR. Very interestingly also, Your Lordship, even in the FIR, my name also was not recorded properly. It is but just a surname. So all that, Your Lordship, technicalities will be before the trial court. But just to impress Your Lordship on section 37, that what are the reasonable ground to show that I am guilty. But in fact, Your Lordship, I've tried to establish myself here, Your Lordship, that there are no reasonable ground whatsoever to show that I'm guilty. In fact, it's the other way around. Your Lordship, another judgment of the Honourable Supreme Court with regard to section 35, Your Lordship, to say that since I was there, so maybe the culpable state of mind should be presumed that I am aware of the contraband. So this is another judgment, Your Lordship. I would like to rely on para 10 and 11 of this judgment, Your Lordship. 10 and 11. I may read, Your Lordship. While dealing with the question of possession in terms of section 54 of the Act, section 54 of the Act and the presumption raised under section 35, this court in so and so, while upholding the constitutional validity of section 35, observed that as this section imposed a heavy reverse burden on the accused, the condition for the applicability of this and other related sections would have to be spelled out on facts, and it was only after the prosecution had discharged the initial burden to prove the fundamental fact that section 35 would come into play. Applying the fact of the present case to the cited one, it is apparent that initial burden of proof that the appellant had the knowledge that the vehicle he owned was being used for transporting narcotic still lies on the prosecution, as would be clear from the word knowingly, and it was only after the evidence proved beyond reasonable doubt that he had the knowledge would the presumption under section 35 arise. Section 35 also presupposes that the culpable mental state of the accused has to be proved as a fact beyond reasonable doubt, and not merely when its existence is established by a preponderance of probability. We are of the opinion that in the absence of any evidence with regard to the mental state of the appellant, no presumption under section 35 can be drawn. So, Your Lordship, this ruling also, Your Lordship, is very much what I'm claiming as a defense before Your Lordship today.
Yes, Mr. Khan, anything?
Lordship, can I take the law that is realized on most of the judgments, Your Lordship. 2011, Lordship, most of the judgments relied on is 2000. The first of all, Your Lordship, the Odisha High Court judgment.
Yes.
If Your Lordship will come to page 4, Your Lordship, in the bottom part, Your Lordship.
Yes.
The citation that is relied on is 2002, Supreme Court 2002. This is the bottom page, Your Lordship, page 4 bottom, just below the end.
Yes.
And then the next page, Your Lordship, 2004. And finally, Your Lordship, the last one is 1979.
Last one.
And page 6 in the bottom.
Oh, he has not relied on this.
No, not relied, Lordship. This particular judgment is relying on 2000. And what my purpose of saying this, Lordship, 2002, 2004, 1979. Lordship, yes. So there are 3 Supreme Court.
It's a case which has been, which has been rather a benchmark.
Benchmark, absolutely.
As far as the principle is concerned.
Lordship, I'm just trying to highlight, Your Lordship, because I'll just come why I'm relying on this, Lordship. So 2002, 2004 and 1979. And the last judgment that he realized just now is 2011.
Yes.
So these are only the judgment that he's relied on. And Lordship, Lordship will kindly, this is the latest judgment of 2021 on the issue of bail, and this court has dealt with it in a number of cases.
Yes.
So Lordship, the relevant paragraph would be, if I come, Lordship, to para 25.
25.
And if you come to page 112.
Yes.
Paragraph between 1 and 2, Lordship, the judgment which Supreme Court has relied is para 22 and 23 will be relevant, and 26.
Yes.
22 and 23 is very important, Lordship. 22. Lordship, I'll just read this. The term, the expression, of course, this has expanded the meaning of Section 35 of the Act itself. So what I'm saying is what is the illumination of law, and so far Supreme Court is concerned. The expression possession is a polymorphous term which assumes different colors in different contexts. It may carry different meanings in contextual different backgrounds. It is impossible, as observed by so-and-so, to work out a completely logical and precise definition of possession uniformly applicable to all situations in the context or all statutes. 23 is relevant, Your Lordship. 23 is very clearly the word conscious means we're dealing with culpability.
Yes.
Means awareness about a particular fact. It is a state of mind which is deliberate or intended. So the thrust is in the awareness about a particular fact. It is a state of mind which is deliberate or intended. Lordship, I'm emphasizing on the word awareness. In so far this case is concerned, awareness. And Lordship, if we come to para 26, not what amounts to conscious possession.
Yes.
First is this, we have to be very clear, there has to be an awareness. And second, what happens when there is an awareness? Conscious possession was also considered in Dharampal versus so-and-so, wherein it was held that knowledge of a possession of contraband has to be gleaned from the facts and circumstances of the case. Allow me to go slow. There has to be knowledge of a possession of contraband to glean from the facts and circumstances. So there has to be a fact, there has to be circumstances. If those facts and circumstances, if it emerges from the accused himself, that will be his consciousness, his mental capability, and once that is there, that means he was aware. So the standard of conscious possession, Lordship, if I am allowed to continue, standard of conscious possession would be different in cases of public transport vehicle with several persons as opposed to a private vehicle with a few persons known to one another. Here it is a public vehicle, Lordship, slightly different, but there were only 2 people. So in so far this case is concerned, the vehicle would not be so relevant as to the number of occupants. So the occupants admittedly was only 2, and the issue would be whether when there are 2 person and whether both the person was aware of what was inside the vehicle, and also both the person was aware in the mental state as to what was in the possession. So for the main accused concern, Your Worship, the evidence is very lengthy. I mean, he is clearly admitted. I don't want to go into that part. He clearly says what he has done. He's an habitual druggist since 1997. He's been transporting, and this is not his first case, second case, third case. But so far, the present accused is concerned, Lordship. Lordship had dealt with on 20 August 2024, a bail application was rejected. And the only situation was whether there is a change circumstances. So to answer in short, Your Lordship, I'll just take Your Lordship to page 148 of their petition.
Page
148. Your client's name is Tambi Gote. Yes. Lordship, the principle of law that I clarified was there has to be an awareness. Now, the awareness and whether he was in the mental state. Now, very important fact would be whether the awareness of the evidence comes from somebody else or it comes from the accused himself. Section 35 will be complied and Supreme Court judgment clearly says this. Now we'll have to see whether this particular fact of awareness has come from whom. If you read the statement of the accused, if I may be allowed to.
This is 161 statement.
No.
This is
Please,
161.
please, just let me complete.
in a bail application, the court can take cognizance of 161, 162.
Lordship, I'll come to it. He'll give a chance.
Anyway.
I was like him decades ago. He's lucky to have a very patient court. Lordship, let me read out on the particular fact. What did he say? My name is so and so. I am a married person and I am currently working as a carpenter by profession. My father was a government school teacher and pensioned this year itself, and I have one brother who is serving in military engineering service and one sister who is housewife. These are not relevant, Your Lordship, but I'm just to bring to the point. I was in touch with Shri so and so since 1st June 2020. First part, Your Lordship. He stays. I'm aware, Lordship, these are not admissible. We're not into that. We're not doing a final hearing. I'm aware of it. But he says he's in touch. That this is his statement. Since 1st June, through a phone calls conversation several times, I came to know that Shri Shonsu was a drug peddler. He phone call, yes, and he several times, yes, and he is in knowledge that he's a drug peddler. The first thing, he knows the character of the main accused. Next paragraph is very crucial, Your Lordship. On 17/6/2023, I had a phone call conversation with so and so and agreed to travel to Guwahati and help him drive the vehicle. I was aware that illegal consignment drugs was concealed inside the vehicle. I was aware. In fact, we don't need Supreme Court judgment even, just for clarify. Section 35 clearly take care of it. It's his admission. There are two very important facts that he has stated. That he is aware of the identity of the main accused. He chose to drive the vehicle. Clearly comes within the meaning of Section 29. That he is willing to abet the cause done by the other accused. And what was the cause? The cause was transportation of a drug. Who happens to be a compulsive drug trader. So his statement here, Your Lordship, of knowing that he is dealing with a drug trader, number one, knowing that he has to drive the vehicle for transportation, number two, is in furtherance of carrying out the drugs, knowing that inside the vehicle, the consignment that he has to drive in a vehicle is a drug.
So in effect, we are looking at his culpability.
Absolutely, Lordship. That's of course. And Lordship, culpability, Lordship has decided. I don't want to waste time except if the Lordship wants me for clarity. Lordship has dealt with length in a number of cases. Custody is not crucial. Section 50 is not applicable. he was aware that he has to drive a vehicle where the main accused is carrying the drugs. No, that clearly comes within the meaning of 35. And who is number one, Your Lordship? He is one of the major person who does drug business. He's been under trial for a number of cases. And so for this particular accused is concerned, the culpability part comes not from any other accused, Your Lordship. It comes from within him.
On his
No,
own admission.
No, Lordship, yes. Now, Lordship will appreciate this. Why I read the judgment and why I'm reading this evidence is for the simple reason that till the last evidence was adduced, that stage has not come. Because 161 statement will get fortified into an evidence and will become an evidence. Lordship, at what stage? When the IO is recorded. And my fairness fairly conceded that the Caesar witness and IO is yet to be examined. When the IO comes to the witness box and then he says whether this is recorded under duress or whether he affirms it or whether he says all the statement was given on his free will. Only for the purpose. Still it will not be admissible because he'll get a chance to cross. He'll get a chance to cross that 161 was never recorded. You drafted it. Then he has got a totally different case. That stage is not before the court. That circumstances is not even arrived yet. That would be circumstances 1. On conscious posture, on the mental capability, or the mental state. Second would be when this question will be framed by the court after the deposition of IO and then 313. Prima facie at this stage, Your Lordship, when we see the statement, this phone details, choosing to drive, and then knowing that is drugs, then what happens, Lordship? Lordship, we have two very important situations, Your Lordship. So far this case is concerned, Your Lordship, I'm very, very, very clear on the evidence. I'm relying on the evidence. There is an open and shut case of 35 at this stage, and there's no change of circumstances. What happened on 20 April 2024 when the bail order was rejected? The change of circumstances will become activated or alive only when the IO is examined. Till then, the stage has not come because this is 161. So there is no change of circumstances. On that ground alone, court will not review this order under 362. Lordship, just not for any other reason, please. The first one is today's reporting, Your Lordship. First page, Xerox. Now, the evidence I have closed, Your Lordship. My purpose of just bringing this to the knowledge of the court is public interest. Lordship, see the Queen Bee part of it, Your Lordship, and see the statement that was made by the Honorable Chief Minister, how he's activated the ADCs. The matter has become so critical, so chronicle, and so alarming that the highest authority in the state has taken the matter and has pleaded that we have to take an action. Now the purpose of reading, putting both this newspaper report today's and yesterday's, Your Lordship, is this: we have a very important legal issue to address, Your Lordship, with a collective liberty of the public. If there is a competing claim,
See, Mr. Khan, that is always one aspect of the matter.
yes, Lordship. After evidence, I'm just reading out with the leave of the court. No intention of pursuing the court anyway out.
We need not go further.
Lordship, absolutely. My whole purpose of saying is, Lordship, the public interest, it has become chronic. And when we read this evidence, in the background of this evidence in the connecting with the amendments, it seems to be like a kind of a main racket. We don't know whether they are the foot soldiers of this Queen Bee. No, we don't know, Your Lordship.
That is stretching a bit too far.
Lordship. So just not to pursue this case, not for the purpose, Your Lordship. What my submission, Your Lordship, is this: at this stage, Your Lordship, the circumstances remain on 20 April 2024 when the bail was rejected has not changed, and prima facie the case has been made out. Your Lordship.
Yes.
Just a reply, Your Lordship. Lordship, with all humility, Your Lordship, what my learned senior have expressed, that from the materials available on record, while relying on 161, which is very clear that it is inadmissible in the court of law until it has been proven in evidence, Your Lordship. Relying on this, Your Lordship, they don't have a case. So we are at the stage, Your Lordship, where 37 has to be dealt with regard to residual, whether the material available on record today, whether it have got any residual ground or not, for this court to decide whether I'm guilty or not guilty. I have placed my case, Your Lordship. There is nothing against me, and the prosecution have come up with 161. Your Lordship, 161 of the CRPC, Your Lordship, that is for other offences. But Your Lordship, this one's statement before the police under the NDPS Act is under section 67. And Your Lordship, if Your Lordship can, I don't know. Your Lordship, this is a judgment by the Supreme Court in 2021 judgment, Your Lordship. This, Your Lordship, section 67, Your Lordship, or whether the statement given to the police, whether it is admissible or not, Your Lordship, has been categorically discussed in Tufan Singh's judgment, Your Lordship. Even though this is not a Tufan Singh's judgment, but this particular judgment, Your Lordship, have reiterate the Tufan Singh's judgment.
As far as the issue of
statement,
the import of section 67, well, that has
yes,
been explained.
Yes, Your Lordship.
So
It is same, Your Lordship. Even in that judgment, Your Lordship, it have been discussed. Like it is an admission before the police. I mean, a statement given to the police. So it comes in the same way, Your Lordship, as under 161. So, Your Lordship, even in coming to paragraph 14, Your Lordship, of this judgment, in the absence of any psychotropic substance found in the conscious possession of accused 4, we are of the opinion that mere reliance on the statement made by accused 1 and accused 3 under section 67 of the NDPS Act is too tenuous a ground to sustain the impugned order dated 15/7/2021. This is all the more so when such reliance run contrary to the rule of Tufan Singh. So, Your Lordship, here also, Your Lordship, the statement, because in this instant case, Your Lordship, it is by the statement of the accused that have been implicated in the matter. So, it is a statement which they have given to the police, and that is where they have arrested me. So, here coming again, Your Lordship, to what my learned senior have discussed, and that with regard to the awareness, because why, Your Lordship, it is a public vehicle. Just because I am there, only the two of us were there, is that an evidence in the court of law to show that I'm also having the same intention with the other accused person? I put that question to myself, Your Lordship, simply because I am there with him. Your Lordship, it is on record where the evidence of a gazetted officer. He is not a mere witness, Your Lordship. He is a very important witness. He was there. He's part of the search and seizure team. He said 1.5 hours it took to discover the drug. So you mean to say, it shows, Your Lordship, it shows that the contraband was not in a place where it is easily accessible or easily seen. So as to show that since I'm there with him, so I'm traveling all the way from Manipur, I would have had that knowledge, that it's there. Your Lordship, that is why, Your Lordship, the section 35 also talks about that mere preponderance of probability, Your Lordship, that is not sufficient to show a case that I'm aware of the contraband. Also, Your Lordship, what my learned senior have said, that yes, even though in one hand he said, this is admission, this is awareness, 161 statement is, I'm showing that I'm aware of the drugs. But on the same breath, Your Lordship, he's also saying that let IO be called so that he'll prove it. So it means that at this stage, there's no evidence against me. IO will still have to come. But what section 37 talks, Your Lordship, is whether at the time of bail, Your Lordship, what is there available on record to show that I'm guilty? If we have to wait for the IO to come, then let the trial court only decide. Why come before this honorable court when the IO have not been examined? IO usually be examined at the end, Your Lordship. So I think so that kind of an argument, Your Lordship.
Yes.
So, Your Lordship, again, with regard to the public interest, Your Lordship, at the last, my learned senior have given a newspaper clipping, public interest. Isn't the accused also a public, Your Lordship? Until and unless that proven that he is guilty. So, Your Lordship, all those kind of submission is just to sway this court from what is the issue at hand, Your Lordship. The issue at hand is that, Your Lordship, under Section 37, it talks about reasonableness, whether there are material available on record. Just my mere presence with as an occupant, and it is a private vehicle, Your Lordship. It is not a case where it is a, it's a public vehicle. It's not a private vehicle. Had it been a private vehicle, then yes, maybe. And so, Your Lordship, that is all my.
See, there are, you have made some reference to the CDR. Where is the reference as far as the
Lordship,
CDR?
there's a number of, Lordship, if I may take, Lordship will just come to, Lordship will come to page 110. I'm glad the Lordship has asked me that question. I thought that was not relevant, but page 110, 11, 12, 13, 14, 16, 18.
If I may assist, Your Lordship, CDR is, the report is at 134.
134.
134.
So Lordship, we're going to the details. First, if Lordship will see the number of details. It starts from 110, 111, 112.
Have you marked what is particular to the accused here?
Your Lordship, as per the report at 134, the prosecution have not provided any such type of marking, but the note, Your Lordship, the finding, Your Lordship, it is noted that both the accused person, Shri so-and-so, and the petitioner herein, Your Lordship, was in touch with each other since 1st June 2023, and several calls were seen in the CDR. What does that say, Your Lordship? And Your Lordship, there's a judgment also on the CDR, Your Lordship, aspect, which I would like to draw the attention of this Honorable Court. This is passed by the High Court of Punjab and Haryana, Your Lordship, 2022.
Already dealt with it.
2022.
In para 20
Since
of the
Your Lordship have asked for the clarity on this, just at page, this is para 10 and 11 again, Your Lordship. Or rather, I'll just read para 11. Para 11. In the judgment of Gujarat High Court in Yash so-and-so, it has been observed as under, having heard learned advocate for the appearing parties, it emerges on record that the appellant is not found in possession of the contraband article. Over and above that, the call data records may reveal that in and around the time of incident, he was in contact with the co-accused who were found in possession of contraband. Since there is no recording of conversation in between the accused, mere contact with the co-accused who were found in possession cannot be treated to be a corroborative material in absence of substantive material found against the accused. A perusal of the above judgment would show that without the transcript of the conversation exchanged between the co-accused, mere call details would not be considered to be corroborative material in absence of substantive material found against the accused person. And Your Lordship, one more point, Your Lordship, which I almost slipped off my mind, and that is with regard to the order passed by this Honorable Court on the last date, where my learned senior saying that there is no fresh ground. Your Lordship, coming to the earlier bail order passed by this Honorable Court, with regard to the new ground, Your Lordship, here, because why, Your Lordship, at para 15, which is at page 158, Your Lordship. 158, para 15 and 16. This court on consideration of the submission is made aware of the facts and circumstances leading to the arrest of the accused person in question. Such fact being that he was apprehended while traveling in a vehicle along with the driver who is the co-accused. The fact that the police, upon search and seizure of the said vehicle, have recovered a large quantity of about so-and-so of narcotic drugs suspected to be heroin, the only person present in the vehicle being the accused in question and the co-accused, there is no doubt that the accused person are in conscious possession of the said contraband. So, Your Lordship, with regard to this conscious possession, Your Lordship, provide the evidence. So that is a new ground, a new development, Your Lordship, that have taken place. Because at that time, Your Lordship, when this particular hearing was done, Your Lordship, evidence was not there. The deposition, witnesses were not examined and cross-examined. So by the evidence that I've produced before this honorable court, the gazetted officer have clearly shown that where is the drugs located at, so as to show that I'm having this conscious possession. So that is, Your Lordship, to say that there is no new ground, no new development, Your Lordship, that is, I think so that will not sustain.
Yes, of course. See, new grounds would be revealed only when in course of the trial,
In the course
of the proceedings.
Yes.
Now, since then, evidence has been recorded of
Yes.
the witnesses. That will have to be looked into as to how would that materially, support your case or not.
Lordship.
Absolutely. Lordship, just one query. Lordship. He relied on the Punjab judgment. That has been technically overruled by the Supreme Court, and Lordship he didn't read out the para 17 of page 158, Lordship. I don't know why he is quoting a...
I have to read since I'm presenting my case.
As a young lawyer, he should understand that he borders around misconduct.
Oh.
If he quotes the overruled judgment. Just for his clarity, for his knowledge. It's subject to him.
Let's hear.
Yes, tell.
Lordship, page 17. Lordship is already held, so I don't know whether he's arguing for a review or for a fresh ground. At this juncture, this court would not give too much credence to the issue of CDR being the basis of proving the innocence of accused person in question. The same to be eventually tested in evidence. As far as the consideration of bail is concerned, other aspects of the matter has to be considered. So, Lordship, we rely on that Nawab Singh judgment. Lordship has dealt it. The Punjab judgment is irrelevant. So CDR is a matter of this. And Lordship has already held it. Now, is he arguing a review petition? I don't know.
Your Lordship, when I started my argument...
1 minute.
It's only when
One minute.
asked for a query on CDR, Your Lordship, that have come in. Yes, only on a query, Your Lordship. Or else
You can't expect this court to be...
Yes, Your Lordship. Just to refresh, Your Lordship.
Remember whatever has
Just
been-
for the sake of
Absolutely, Lordship. That's why I was relying on para 17, because Lordship has dealt with it. And the only thing was this, in spite of the fact court has held, he still wants to rely on a Punjab judgment.
Just to refresh, since the court have
But you can't
asked
rely
for a
on...
query.
So, Lordship, my only submission would be, Lordship, that stage of where I read out, that stage is yet to come for the IO. So, there's no change circumstances, and court is already held prima facie. He read out para 13 and 16.
For the parties, I'll pass this orders.
Oblige, Lordship.
Okay,
Highly obliged, Lordship.
Item number 1.
Please, Your Lordship. Lordship, I pray this matter may come at the end of the board, Your Lordship.
Control you. Didn't he? Didn't he? Fine.
Item number 3.
Please, Lordship. Lordship, I filed my written argument, Lordship.
Yes. What about the
The others, they have filed.
respondent 6?
Respondent 6.
Who's respondent 6?
Your Honor, I'm for Your Lordship, I'm for respondent number 6, and I'll be filing the written argument. Lordship, I'm for respondent number 7 and 11, Your Lordship. Already been filed, Your Lordship. We are for respondent number 8, 9, 10, 12, 13, 14, 15.
Have you also filed your... Is it necessary to file? But any...
On the last mission, you relying there.
You're fine. So everything is complete. Then?
Everything is completed.
Is the H. Harmi, the additional senior G, has submitted that the written argument on behalf of the state respondent has been filed today. Similarly, Mr. Learned Counsel for the respondent number 6 has also submitted that the written argument on behalf of such respondent has been filed today. Accordingly, the Learned Counsel for the respective parties have then submitted that since all the written argument required to be filed by the respondents have been done so, matter can be now posted for judgment. The petitioner has filed. You have
Yes,
filed.
Your Lordship.
Accordingly, this matter is now reserved for judgment.
Yes, Your Lordship.
Item number 4.
My lord, this is the matter pertaining to Education Department, my lord. In fact, there are several writ petitions pending before this honorable court also and with the other bench also. Now, what government has submitted, because these are arising out of certain rules of the Education Department, which say that after completion of certain years of service, they'll be upgraded, my lord. Now, the state government has submitted in the other matters that government is having a comprehensive look at the policy, my lord. And some committee has been constituted for the purpose, or either way, there, because that particular provision has created a lot of anomaly in the service, my lord.
Okay. What is the subject matter of the?
What is the subject matter, my lord? My lord, page 59 is the order passed by this honorable court, my lord.
Page
59.
Yes.
Now, my lord, by this order, my lord, of 6/9/2019, the petitioners, the 70 number of petitioners in that particular case were granted relief, my lord. May I just read this order, my lord? Para 1, my lord. The instant writ petition has been filed by the petitioners who are serving as sub-inspector of school under the Education Department of the Government of Meghalaya with the grievance that the time-bound upgradation as provided under Meghalaya Service Rules 2012 has not been afforded to them in spite of they being eligible and due for the said promotion. As such, they are before this court seeking a mandamus for upgradation as per the said rules. Dr. So-and-so, assisted by so-and-so for the petitioner at the outset, has submitted that an aberration has been made in the affidavit filed by the state respondent that active consideration is in progress for considering the upgradation of 20 posts of sub-inspector of schools to the post of additional SDSEO, and the same is evidenced by the letter dated 25th June 2019, which is annexed as Annexure 6 to the affidavit in opposition. He further submits that the upgradation, if so given, should be from the date when the petitioner became entitled for the same so as to enable them to enjoy full service benefits. Mr. P. Bhattacharya, learned AAG, assisted by so-and-so, for the respondent 1 to 3, submit that as per the letter dated 25th June 2019, it is clearly stated herein that the department is to take immediate action by using upgradation order based on seniority, as sanction has already been afforded to 15 posts, and that for the upgradation of the remaining 5 posts of sub-inspector of school to that of additional SDO, the same will be made in by issuing fresh sanction orders. On hearing the learned counsel for the parties, I propose to dispose of the instant writ matter at this stage itself, based on the submissions and the letter dated 25th June 19. For easy reference, the letter is so-and-so. And next. On a bare perusal of the letter dated 25th June 2019, it reflects that the respondents are to follow the procedure as laid down under Rules 8 and 9 of the Meghalaya Service Rules, and as per the due procedure, immediate action should be taken by issuing upgradation orders for 15 posts of sub-inspector of schools to that of additional SDO, and for the remaining 5 posts, upgradation be done by making a fresh sanction. In view of the facts and circumstances of the case, the writ petition is closed with the direction that there is no impediment for the respondent to act on the terms of the letter dated 25th June 2019 for upgradation of the petitioner's post to the post of additional SDSU from the date of entitlement of the same upgradation. The course of action as proposed by the letter dated 25th shall be completed as expeditiously as possible. Well, pursuant to that, my lord, next page, lords will see.
Yes.
The order was implemented by the government, my lord. In pursuance of the Departmental Promotion Committee meeting held on 9th March 2020, the following sub-inspectors of schools in order of seniority who have completed 8 years of service as on the date of their entitlement are upgraded to the post of additional DSCO with effect from September 2014. Duly approved by the department by letter number so and so, so and so, so and so. So 15 as were sanctioned in the order, my lord, and subsequently 5 more have been upgraded, my lord, the page 64. Now what has happened, my lord? The petitioner's case is, my lord, that they are also similarly situated. They are also sub-inspectors of the school, and on completion of 8 years of service, they are also entitled to upgraded to the post of SDSU. My lord, may I draw lots of attention to the rules, my lord?
My lord, in this matter, if lordship permits, my lord, we have been instructed to submit that the matter is under review. It's under review, my lord, the committee.
That's what he has said so, but he is briefing the court on what is the subject matter herein.
Page.
So the petitioner is also.
My lord, they are also sub-inspectors of the schools, my lord. They have completed 8 years of service, so they are also entitled to. But the rules say, my lord, sub-inspector of school, the moment they complete 8 years of service, automatically they will be upgraded to additional SDSU, my lord.
So, you see, since 2020,
my lord,
till date, so in the intervening years,
my lord,
they have come up in the zone of consideration.
My lord, that is why they have come before lords.
But why would that order not cover them?
My lord, here there is some problem, my lord. What happened after this order was passed, my lord, by Justice? Thank you. My lord, another order has been passed. I'll just place this order, my lord.
Yes.
But here what happened, my lord, lordship kindly see the last para 5.
Yes.
I'll read from para 4, my lord. But that was a separate. This was a separate matter, my lord. But in this matter, by this order, the seniority that was given from 2014, my lord, that has been affected, my lord. And that this is what has created a lot of complication in the matter, my lord.
Okay, so now, so that would relate to the computation of that 8 years period.
My lord. My lord, what this honorable court by this order said, my lord, that their seniority will be counted from the actual date of promotion, not from 2014. So, my lord, in this case, your lordship has seen that the promotion orders were passed on. First was on 11th March. Both in fact are on 11th March 2020. And the promotion order itself says, my lord, with effect from 1st September 2014. Page 63 lordship has noted, my lord.
Yes, yes. Page 60.
63.
But this is with regard to those earlier.
Earlier petitions, my lord.
So this is with effect from?
In the 5th line, my lord, with effect from 1st September 2014.
Yes, 2014.
And this has this was after the in compliance of the order of this honorable court, the retrospective promotion was given with effect from 1/9/14, my lord, 1st September 14. Now this order came, my lord, in 2022. That has affected their seniority, my lord.
Okay.
Now, if I may just read to take a lordship to para 4 and 5.
Yes.
In this regard, the averments made in para 8 of the affidavit will suffice, as it answers the query and addresses the concern of the petitioners. The same is reproduced herein below. That with regard to the averments made in para 11 of the writ petition, the answering respondent states that it is true that the process of upgradation involves the same, and that additional SDSEOs are entitled to recon their seniority from the date of actual appointment, that is 11/3/2020, and not from the date with effect from which their posts were upgraded. The next para, my lord. Accordingly, in view of this development and the stand of the government that the additional SDSCO are entitled to recon their seniority from the date of actual appointment, that is 11/3/2020, and not from the date with effect on which their post was upgraded, nothing survives. Now, my lord, this has brought back the situation, my lord. Now, of course, they have been given the upgradation, my lord, but not on the date they completed 8 years of service, my lord. This has postponed their promotion by 6 years, my lord.
Exactly. But you have not appealed against this order.
But actually, what happened, my lord, the petitioners, they didn't come forward.
You see, if they have been, if they are affected by this,
they are affected by this order, my lord.
they should have.
My lord. And my lord, not only this, because of this order, my lord, the other writ petitions, even this writ petition which is before your lordship, my lord, that has been affected. Because now it says that they are not entitled on completion of 8 years of service, but from the actual date of promotion. In fact, there are other matters in the other court also, my lord.
Yeah. But this order will come in the way of all.
Is coming in the way, my lord. Now, in fact, we have made a prayer before because in the other matters that this order should be reviewed, my lord. The court can suo motu also review this order, my lord. Okay. Because this order was passed without any proper hearing, my lord.
The court cannot take special interest in any matter.
No, the other court, my lord.
If it is related to a,
my lord, in the connected matter, my lord. In the connected matter, this is again becoming an issue in the other court also, my lord, where the connected matters are pending. In fact, we made a prayer also. This order is coming in the way, and this has created a lot of. This has upset the entire thing, my lord.
What's the government view on this?
My lord, I do not have a clear picture of this entire issue. Mr. Sen and Zed Inongkandri are the counsels for
it might involve a policy decision,
my lord, it seems what I have been informed by my colleague is that there are some a committee has been constituted to study this entire issue. That's all my instruction is, my lord. Since both of them are not present today, my lord, Mr. Sen is on legs and Zed Inongkandri is unwell. So, my lord, I have limited instruction to apprise this honorable court, my lord.
This order has come as a bolt from the blue, my lord.
So what happened is, you see, as far as this matter is concerned, it would be.
Now, at most, we can pray that we should be given prospectively, my lord. Now, retrospective is gone by this order.
Prospectively,
we are still entitled, my lord.
Because that is, of course. Then there is no, you see, there's no.
But prospective will not serve the purpose, my lord. They're entitled since 2017, 2018. The government will give now, my lord, the 5-6 years of service is washed out.
But in any case, they are fighting for their promotion.
They're fighting for promotion.
So if that is given, at least one hurdle is crossed.
At least one hurdle is crossed. But now, my lord, we cannot come back again, my lord, seeking retrospectively. So that's why if the government can come out with a clear policy.
That is why, you see, only the government policy can upset this ruling.
My lord.
See, if Ms. Kunni is saying that it's under consideration, then we'll have to.
We can wait for another a week or 10 days, my lord. Immediately after Puja vacation, they can expedite it. It's not a very complicated matter.
We will follow up, my lord. We can come after Puja vacations.
Then we can additional 2 months. That also expired 5 months. But Ms. Argoli was Learned G was submitted that on being instructed, it is reliably learned that the case of the petitioner is under the case of the petitioner and other similarly situated employees are under is under consideration, active consideration by the state government. And as such, sometime it will allow for the concerned authorities to take necessary action in this matter. So now it's only for you to pursue the matter at a personal level with the state government to ensure that whatever is to be done is to be
That
done.
is one aspect, my lord. Otherwise, of course, we are entitled to promotion. There is no doubt about that, my lord. But retrospective is the only question hindrance now.
Exactly.
Now, for that also, if the other court clarifies that.
So that is why I said this. The fate of this case is dependent on
Two things now.
on other cases.
Other cases and the government's policy also.
And the government's policy. We'll leave it at that then. Premate list matter of the 3 weeks.
Deep.
Second court from daily list, item number 1.
But here I was required to file. I have received instruction, my lord. The instruction is very short. They are saying that we have filed application under section 36 of the NDPS Act for extension of time for investigation before the 180 days expired.
Oh yes, but is that on record?
That is on record, my lord. But of course, the order was passed after 180 days, my lord. But the application was filed before that.
Can you see now? The only thing that you have to first state the precedent or the.
Well, in fact, that is an admitted question. They also don't deny that application was filed before that. Do you deny that?
No. My lord, I will advance my arguments accordingly. Then my lord will understand, my lord, because my lord, they have filed the application, my lord, for extension of time on 180 day, my lord, because they for commercial quantity till 180 day, my lord, according to section 36 is subclause 4 of the NDPS Act, my lord. So they have filed the application. But my lord, the question here is that, my lord, when the application was filed, the application was not decided on that particular date, my lord. It was heard on the 18th July 2024, my lord. When my right had accrued, I have filed the application, so I am entitled for default bail. And my lord, the learned trial court had wrongly rejected my default bail application, my lord. So, and my lord, I have the judgment of this Honorable Supreme Court which supports my submission, my lord. And I have also made similarities, my lord.
So dealing with that issue. See, because now the only consideration here is.
But that is only consideration
whether you see the court taking cognizance of an application file.
Yes, my lord.
Would that be material as far as the calculation of date is concerned? Otherwise, if we say that it would come into effect only when the actual order is passed, then you have a case.
Well, what I pray the matter comes on Monday. I'll do some research on this till Monday.
My lord,
if there are case laws available. You have cited precedent.
My case law. I'll come on Monday only.
My lord,
Monday for 2 days.
My lord, on Monday, my lord, I'm not free, my lord. I have some other matters also, my lord. So my only humble submission is that, my lord, on the last occasion also, my lord had reflected clearly in the order sheet that no more adjournment, my lord.
But now he's saying that he needs time to
just for decisions, my lord.
Yes, for the decision. That is only, I think that's the only
legal
issue
question
to be decided.
Yes.
More particularly the role of the court.
Yes, my lord.
Once application filed in time, my lord.
I think there are
some judgment.
There are some judgment.
If I remember Sanjay Dutt's case, I think is the famous case in that, my lord.
What is
the film star, my lord? That is the case. But I'll just look into that, my lord. And whether that has been reviewed or what is the latest position, my lord, I'll just place that.
My lord, but this judgment of Jasbir Singh clearly says that, my lord, once the application filed, my lord, for extension, it has to be decided there and then, my lord.
See, that of course it has.
There is no order, my lord.
But the point is, see, you also have to consider
yes,
the constraint faced by the courts.
Yes, my lord.
It could happen that the matter was taken up at the fact end of the day, when there is because of paucity of time and all those things. All those things has to be.
Yes,
we don't
yes,
know.
my lord.
We don't know what.
Yes, my lord.
So the only thing is we'll see what the law says.
Yes.
With that particular, as far as that particular issue is concerned.
Yes, my lord.
Whether it becomes effective when the application is filed.
Yes.
Or effective when the order is filed.
Okay.
Or if no order is passed, whether their application becomes null and void, and their application has to be
Yes,
considered.
that
That's
is
the only
also
question.
another aspect of the matter to look.
Monday or Tuesday, my lord, whenever.
On the 1st of October, my lord. 1st of October. Monday is the 30th, my lord.
1st of October is Tuesday.
Yes. Tuesday, my lord, yes.
I was saying Tuesday, you were saying first. So which
Oh,
is
yes,
correct?
yes. I'm so sorry. I was confused, my lord.
Mr. Dr. N. Musica, learned TSGI, at the outset has submitted that he may be allowed to furnish relevant authorities as far as the main contention in this petition is concerned. The same not be objected to by the petitioner. Matter is adjourned. That is adjourned. As agreed to by the parties, this is matter on first.
Highly obliged, my lord.
Highly.